Hey, it's Braulio Rosa with the Broward Bar Buzz, and today I'm here with Debbie Klauber of Haliczer, Pettis, Schwamm. She is the chair of the Appellate division in her firm. She's also a board member of the Broward County Women Lawyers Association, and she's the chairperson of our Appellate section. Plus, she writes the case law update in our Barrister. Welcome, Debbie.
Thanks for having me.
Wonderful. So today we're going to talk about the Tort Reform, and that's really been impacting lawyers and everyone across the state since March. So can you just give us a basic outline to start off of how that's been impacting cases and folks?
Sure. So this was all the rage and all the talk back in March when the Tort Reform Act was signed by the governor. Everyone was rushing to file new cases because of some of the changes that were coming about. And in fact, it impacted a lot of different facets of the case law in Florida. It affects property claims, it affects personal injury cases, medical malpractice cases, when these claims need to be brought, what kind of recovery the plaintiffs can have. And there was a lot of buzz, a lot of conversation about it back then, but it sort of has petered out. Everyone's filed the cases, but today, I thought we could talk about a new spin on that, talking about how now it's really being applied to the cases.
Right. So I know off camera before we started, we were talking about how whenever this took place, it was March of 2023 that when this law was enacted, supposedly it would not impact the cases that were filed before that date, thus the rush to get everyone to file before it happened. I know that like thousands of cases were filed, but yet we were discussing, you said that actually some of the cases that were filed beforehand are actually these new rules are being applied, these new laws?
So right, some of the changes that were enacted in March of 2023 when this change came about are being applied to cases that were there a long time ago, cases we filed last year, cases we filed the year before. And when the legislature put together this bill, it actually expressly states that it won't apply to cases unless they are filed on or after the date that it goes into effect. Exactly the reason why 200 and some thousand cases were filed in March of last year, because the firms all wanted to make sure that their cases were filed before these changes went into effect so that these changes wouldn't apply. But in fact, what it's come down to is as we get closer to trial in some of these cases that have been around for a long time, long before March of 2023, but being tried after March of 2023, there have been some efforts to apply certain portions of that law to older cases.
And so how has that been done? How are they trying to apply this law to these older cases?
So there are two examples that we've seen in our practice. One example, one of the changes that went into place is the fact that if you are a plaintiff who is suing for injuries, a long, long time ago, there was a change between contributory negligence and comparative negligence. And if a plaintiff was at fault and they had any fault in the accident at all, they couldn't recover. That eventually evolved to be, well, everyone should be responsible for their fair share, right? If this plaintiff didn't stop at the red light and the defendant came around the corner too fast, everybody sort of bears some responsibility. You only need to pay for your fair share of the responsibility. But a plaintiff who was injured could still recover. What they've changed the law back to now, which is a little bit of a step backwards from where we were, is that if the plaintiff is found to be more than 50% responsible for their injuries, they cannot recover at all. So I'll give you an example. One of the examples is a case that we had. We had a 14-year-old boy who had been struck by a car and killed on a construction site near I-4 in Orlando. He was crossing the street at night. There was a construction zone. We had challenges about lighting, about the crosswalk, about what was really going on in this intersection. But there was some suggestion that he might bear some responsibility. We sued the driver of the vehicle. We sued the construction companies that were involved in the construction. We took that case back in 2020 or 2021, and as we were nearing trial, the defendants were trying to amend their case to say, well, he's more than 50% responsible, then he won't recover at all. Now, based on the way the law was written, that it shouldn't have applied to that case, that shouldn't have been an issue. So we ended up resolving the case without trial. So I don't know what the judge would have done, but that's one example where we saw the attorneys for the defense trying to apply this new law to a case that had been filed long before the act went into effect.
But that doesn't make sense. I mean, if you look at the law, right? I mean, if it was filed before that date, it shouldn't really be applied. I guess that's just smart attorneys on the other side trying
Right. We're attorneys. That's what we do. We test the limits, right? We want to see how far we can push it. So the law very clearly says that it only applies to cases filed after that date. But, we push the limits. And the other place where we've seen it happen a lot is with respect to medical expenses and what evidence the jury gets to see during a trial. And I've seen this now on multiple occasions. And in fact, there are copies of circuit court decisions from all over the state kind of being passed from hand to hand, because these aren't reported appellate decisions yet, but there are circuit decisions going both ways. Some judges are applying it to only the newer cases, and some judges are applying it also to the older cases.
So go in depth a little bit on the future. I know we were talking about like the future recoverable monies now and how that'll be impacted versus how it was, I guess, before the law was signed.
Sure. So medical expenses are a big part of the recovery in any personal injury case, right? Whether it's a personal injury case or the medical malpractice cases like we handle, one of the things you want to recover for is not only the medical expenses that I've had to pay because of the injury that was caused, but the medical expenses that I will have to pay in the future to take care of any needs. And, you can't really predict exactly what will happen, but you only get one day in court. So historically, the jury was allowed to hear about all of the medical expenses that a personal injury or a medical malpractice plaintiff had been charged. What did the hospital charge? What did the healthcare providers charge? What was the value of those pharmacy, medications and other therapies and things that were necessary? And after the jury entered its award, the judge would sort of get behind the scenes and see what amount really was owed as compared to what was billed by those healthcare providers. We all know insurance companies pay less than the hospitals bill. Medicare pay often even less than what the hospitals bill or what we would see on some formulary as the charge of those expenses. So the judge would decide it after the trial. But the jury got to hear the full value of the medical expenses that had been billed, because not only is the jury awarding what you've paid already, but they're trying to predict what you'll need in the future. So the way the law has changed now is that the jury will only be entitled to hear the amount that you as the injured person actually owe. So it's a far different number. It's almost a fictitious number compared to what was billed. And, the proponents and the opponents will say different things about what the jury should and shouldn't hear, but it has significantly reduced the number that will actually be presented to the jury at trial, as for the past medical expenses.
I mean, that would seem to be a total tee-up for the defense to really minimize the amount that potentially...
It is a favorable position for the defense to show less dollars to the jury at the end of the day. And I think for the past, it's easy to see both sides of it, because in fact that really is what you owe. But the challenge is when you're talking about the future damages. So all of that on some level is a little bit speculative. We're trying to guess what someone who's injured today is going to have to pay for medical expenses throughout their lifetime. So
let me ask you something, though. As a trial attorney, someone's in there, are you limited? So they're saying, let's say, hypothetically, so person X owes $100,000 in medical bills, right? But it really costs $300,000. As the attorney speaking to the jury, then you're not allowed to say anything about what the full cost was.
Correct.
Or can you somehow allude to, well, my client owes $100,000, but that realistically there was, there's a lot more cost that went into that.
You can never talk about insurance in front of a jury in a case like this.
Wow.
The jury isn't supposed to think that insurance is there. The jury isn't supposed to consider the fact that someone may or may not have insurance coverage. So probably that would lead you down a path you don't want to go down.
Okay. Interesting.
And it really does limit what evidence. This is an
Yeah.
issue that comes up. It's come up for years because there's always been this ongoing debate. And it's always an issue that you address with the court before trial. And the case law has been pretty clear. We're going to let the jury hear all of it, and then we're going to let the judge award only what's permissible so that the plaintiff doesn't have a windfall and get more money than
Sure.
they should have.
Yeah.
But it's the future damages where that's really a challenge because you're guessing what's coming. And if you're an injured plaintiff, it'd be better to have a little bit more than you need than to not have enough. So what's happening now with respect to the future damages is that the jury's award will either be based on whether the plaintiff has health insurance, whether the plaintiff has Medicare, Medicaid. That's the value of what they can recover. And if they don't have any insurance at all, then these experts are going to need to apply the rates that the government pays for that medical care, as opposed to some other reasonable estimate of what that medical care might cost in the future.
Wow. So it's granted depending on the type of insurance you might have or might not have.
And it, of course, kind of assumes that you will have that coverage available
Right.
in the
I was
future.
thinking if you were terribly hurt and you have XYZ insurance company, they're in it for the money, let's be honest. So why are they going to keep you?
A lot of that
I would assume
is
they
the
dump
uncertainty of the future. And, we say it a lot when it comes to our clients and our patients. They only get one day in court. We have to do the best we can for this day for the rest of their lives.
I'm assuming anyone that's been catastrophically hurt like that, because these are the kind of, or at least pretty bad for you to be able to go in, they're probably not going to have insurance after this is all done. They're going to have to pay for it the rest of themselves.
And you certainly don't want to bank on it, right?
Yeah.
You need that money going forward. And what the life care planners do is they speak to the healthcare providers, whether they're treating physicians or expert witnesses, to say, this is the plan. This is what this patient will need going into the future. And then we do kind of have to guesstimate what the cost will be based on what the cost is today, based on inflation. We were all talking about that, based on the time and the benefits that will be available, and all of this. Even the case law discussing this in years past has talked about how it is sort of speculative. You can't say, well, we shouldn't have to pay for these damages because you can go get care under the Affordable Care Act. Well, nobody knows whether these benefits, these public benefits, these public health insurance will be available going forward. So we're really limiting. We haven't seen it in practice yet, right? This is the new law, but we're really limiting what an injured person might be able to recover to care for them in the future, and that could be a challenge.
How are you guys preparing yourselves to deal with this now, with all these new cases moving forward?
So we'll be working with our experts. I mean, that's what we'll need to do. It's a little bit, it's untested as of yet. Certainly in a world like today where lots of us are talking about inflation and interest rates and all of those things, all of that should still be part of the consideration. Even if a client is limited to what an insurance company would pay, they shouldn't be limited to what that insurance company would pay in 2023 if we're talking about, their ability to get this care going forward in 2033 or 2043 or 2053. Right. So it will be something we'll have to do hand in hand with these experts, not just the medical experts, but the economists and life care planners, and a way to best present to the jury all of the care that our patients will need in the future.
And what about, it's my understanding you have to file cases. You don't have the same time frame, so it's something you would have to file much earlier. So
one of the other changes that was pretty significant to personal injury and negligence cases, so that would be car accidents, slip and falls, trip and falls, accidents on someone's property. Those cases have always had a 4-year statute of limitations. So you've got 4 years to file that lawsuit from the time when, you're injured or you know that it was because it was someone's fault. Sometimes we need time to go and treat and see if the injury is going to go away, if the challenges resolve, or if really we're talking about a permanent and substantial injury that's worth pursuing. So that's always been 4 years. It's now been cut in half to 2 years. You only have 2 years from the time to file your negligence claim. It's always been 2 years in my 25 years of practice, almost 30 years of practice. It has always been 2 years for medical malpractice cases, and it's a short time frame. You have to act
2
quickly.
years.
It's 2 years. 2 years to file that lawsuit. And a lot of times, we've all had injuries and surgeries, and we know it takes time to recover. It's hard to know really, what your future damages will be when you're at the 2-year time limit. But now the legislature has said that's the time limit we're going to give you, presumably just to reduce the number of cases that get filed.
So Debbie, what would be your advice to a solo practitioner or a small firm that has a client and they're looking to refer to you the case? How should they prepare their client?
I think the most important thing in light of these new changes is that if you've got a client, a friend, a family member who's been injured, you want to get it to an attorney as quickly as you can. It takes time to investigate these cases. It takes time to get in on the malpractice side of things. We're required to get experts involved before we can ever file a lawsuit. And all of that's time consuming. And when you're talking about a 2-year statute of limitations, it's not as long as it sounds. So that would be the most important step, is to confer with an attorney as soon as you possibly can.
Sooner than later.
Sooner than later.
Amazing. So how do people get a hold of you if they're looking to get in contact with you? What's your
Sure.
email?
What's my handle?
Yeah, what's your handle?
So my email is dklauber@hpslegal.com. Our office number is 954-523-9922. We have offices here in Fort Lauderdale and in Orlando. I do the appellate and trial support work statewide, and we do cases statewide. So we'd be happy to help anybody who's interested and who needs our assistance.
Thank you, Debbie, for spending the afternoon with me and educating us a little bit on the impacts of this new tort reform law.
Nice to be here. Thanks.